Hi, everyone. Welcome to Combat Boots to Red Bottoms. Today, we have our presentation on intellectual property, and thank you for joining us today. Now, I know some of you think that, hey, the only way that I can get into these presentations is if I am a member of Combat Boots to Red Bottoms or if I'm military or something of that nature. Well, you're in luck because we don't just offer our classes and our presentations to just us members of Combat Boots to Red Bottoms. We open a lot of our training, a lot of our presentations to the public. The reason being is because you never know who you're going to partner with, and all of us need to have these resources and need this knowledge if you're thinking about starting a business and other things that we talk about. Now, there are certain things that we do not put on our YouTube page. You may be able to attend the live training. However, you may not see it on our YouTube page. And those are very few of our videos. An example of that is our 8A certification. So our 8A certification training, what we did was the replay is only available to Combat Boots to Red Bottoms members. So if you're not a member, you won't see that replay. Right. So that is one example, but a lot of our training is on our YouTube page. So if you did not get a chance to attend the live training, then you can also, look in our YouTube page to catch up. Now, I have done all that talking and I didn't even introduce myself. I am Letitia Holmes. I am the founder of Combat Boots to Red Bottoms, and it is definitely a pleasure to be the founder. I love working with the ladies. Our ladies are military women, past and present, and some of them have businesses. Some of them are thinking about starting businesses, and some of them just want to support. So even if you're a civilian, you can support Combat Boots to Red Bottoms by visiting our website and find at www.combatboots2redbottoms.com, or you can actually find us on Facebook, LinkedIn, Instagram, and we even have a TikTok, believe it or not. So, all right. So what I am going to do is I'm going to make sure that you have the link to Combat Boots to Red Bottoms. And if you go there, you can find out more information about us. What I sent in the chat area is and a link to our directory where you can go support the women of Combat Boots to Red Bottoms and their individual businesses. And the second link is directly to our website where you can learn more about Combat Boots to Red Bottoms. You can also sign up for additional training and other programs. And while you're there, please visit our partners. That tab is our preferred partners. We encourage you to support those who support us. Our partners have made a commitment to support Combat Boots to Red Bottoms mission, which you can find out more about at our website. So let's get started. So today we are going to be talking about intellectual property. And I commend all of you who are coming in to attend this because that means that you are really getting serious about your business. We have a super treat for you, and that is attorney Josh Leggett. He is a part of the Nichols and Ash law firm, and I'm gonna tell you, he is just amazing. Now, he was not sure that he could make it today, so he went even the extra mile and recorded his presentation. All right. So I am going to save him at the end so he can answer any of your questions. And if you have questions and you don't want to ask them straight out, you can also put them in the chat and we will be monitoring the chat. So
I was going to say, if I cut you off 1 second,
no.
I think my information is at the end, so I'm always open to phone calls and emails as well. So
yes, I was just going to say hi, Josh.
So if you don't want to put it out there, which I totally get, feel free to shoot me an email or give me a call anytime.
All right. So I am going to start the presentation that he recorded for us. And while I'm doing that, while you guys are watching that, I'm going to see who else is having problems that was trying to get in at 6. So let me go ahead and share our screen here. And let me know if you guys cannot hear the presentation.
Hello, my name is Josh Leggett. I want to thank you for being with me today as we discuss intellectual property. First thing I want to do is tell you a little bit about myself. I am an attorney with Nichols and Nash PLLC. We have offices in Jackson and Ocean Springs, Mississippi. We're primarily a business services and commercial real estate firm, but we also offer estate planning services and handle litigation as well. Now, what we're going to talk about today, as I mentioned, is intellectual property and how intellectual property factors into your new business and whether or not you need to protect it and how. So with that, kind of let's get started. Now, what is intellectual property? Intellectual property can be copyrights, trademarks, patents, or trade secrets. Now, these various different items of intellectual property are important because they can be the essence of your business. They can be what or how your business makes money. In other words, they're what makes your business valuable. So let's get started with copyrights. Now, copyrights can be books, lyrics, movies, computer software. They can even be plays or choreographic works like ballets or dance movements, and even paintings, pictures, and sculptures. And what is required for copyrights? Copyright requires originality, meaning it requires some type of creativity. Now, this doesn't have to be some novel item, but it does have to have a level of creativity. Now, it has to be a fixation on a tangible medium of expression. So in other words, it can't be just an idea, but it rather has to be a physical expression of that idea. Now, another item of copyright is it can be used for content on the internet, such as blog posts or even pictures. Some websites can claim copyright over some of the interactive media on their websites. So it spans more than what we just mentioned. So what about protecting copyrights? Well, for a copyright, protection exists from the time the work is created on that fixed form, even if you haven't registered it with the U.S. Copyright Office. Now, you can register it with the U.S. Copyright Office, and that has some advantages for you. It provides evidence of the copyright's validity. It's a prerequisite for instituting a suit for copyright infringement, and it allows for additional damages as well. Now, at the very least, what you should do if you have material that you want to copyright or protect is you need to put that Circle C on it. I know you've seen that. If you flip to your nearest book, you'll see it on the inside cover, which gives notice to everyone that that is your copyrighted material and prevents others from some type of innocent infringement defense if you needed to pursue damages. It also clears up the confusion on who the author or the creator is. In other words, it's kind of your stamp that that's yours, and you're putting the world on notice that that material is yours and you've copyrighted it. Now, a few miscellaneous items that we should discuss. If you create a copyright material with another or like an employee, you probably need to enter into some contracts or some type of contract with them so that the authorship is appropriately determined and that who can use that work freely. Another item is that copyright owners are permitted to reproduce and distribute that works. It is considered personal property. That way they can assign it, or you could assign it, sell it or license it. For works created after 1978, the copyright protection begins from the moment of creation, which we discussed, but it also endures for a term consisting of the life of the author or you in 70 years after your death, meaning that your estate and or your heirs could benefit from that work. Now, some of the fees for registration, these can range anywhere from $35 to about $100. And it just depends on what and how you're registering. You'll just need to go check out the U.S. Copyright Office website, and it will give you a schedule of fees, and you can determine what your fee will be depending on what you need to copyright. Now, the next thing we want to talk about with intellectual property are trademarks. The point of a trademark is to protect your brand. Now, if you look on the slide there, it has some of the more famous trademarks in the marketplace. And that's what they're doing by trademarking these, is they're protecting their brand so that we don't confuse them with someone else. Now, a trademark can be a word, design, a phrase, or even the product packaging. But the point is to make sure that consumer knows that you are the real McCoy out there in the marketplace. You know, like we talked about, some of the more common examples are the McDonald's symbols, the Adidas, Coca-Cola, and the FedEx symbols, which are symbols we all recognize. Now, what do you want to do to protect your trademark and trademark protection? There are a couple ways. The first being common law. What that really means is just by starting to use your brand out there in the marketplace, you start to build rights in that mark. Now, there are some limitations to that, but nonetheless, you start to gain some type of ownership over the mark. Another way is state registration. Many states have laws protecting trademarks as well as registries that you can do. Again, there's some limitations on these. Now, the bulk of what we're going to discuss today is federal registration. Now, to federally register your mark, you will register it with the United States Patent and Trademark Office, or you'll apply for an application with the USPTO. There's a screenshot there on the slide. Now, there are natural hurdles that you have to meet and or cross to obtain federal registration. The first one is that you must be conducting interstate commerce. Interstate commerce simply means that you're doing business between two different states, which gives the federal government authority over this area. Now, if you're not currently conducting interstate commerce, but you want to try to protect your mark and you intend to do interstate commerce, you can file what's considered a 1B application. A 1B application just simply means that I'm not doing interstate commerce yet, but I plan to do so very soon. And so I want to go ahead and begin protecting my mark. And what that does, it starts the application process so that once you do start conducting interstate commerce, you can file updates with the USPTO and eventually obtain your official registration. Another area that or a hurdle that you'll need to cross is that your mark will need to, or rather I should say, cannot be descriptive or generic. What does that mean? So a mark is descriptive if it describes the ingredient, the quality, the characteristic, function, feature, purpose, or use of the specified goods or services. So an example would be if you wanted to register the word mark bed and breakfast registry, and your business was a lodging reservation for that service. In other words, you are describing what you do and your mark describes what you do, so that will not comply with USPTO rules and regulations. So you would be unable to pursue a federal registration on the principal register. Now, another area or another way that you will be refused if you seek a trademark registration will be if your mark is generic. What that means is just what it says. If you were to try and register the mark milk for milk, you would be refused because that is generic. So your mark needs to be fanciful or arbitrary if you want to get the full protection from the USPTO registration, federal registration. And what that means is your mark must be unique. So a prime example here is the term Apple for Apple computers. That is fancy and arbitrary under USPTO standards. And now another hurdle that you'll need to pass during the application process is to make sure that your mark is not likely to be confused with an already registered mark. And what does that mean? That means when you apply for registration of your mark, the USPTO office will examine your mark to see if it is similar to another mark that's already registered or is in the application process. And really what that means is that they would look to see if the consumer would confuse the registered mark with your mark. And if so, they'll likely refuse to register your mark. What you'll want to do is, before you make your application, is do some of your own due diligence or have a trademark attorney do your due diligence to make sure, or to the best of your ability or their ability, that your mark is not confusingly similar with others. Now, what are some of the benefits of federal registration? There is a presumption of ownership of the mark throughout the entire country, meaning that there's an initial presumption that you do own that mark throughout the United States. Your mark will be listed in the USPTO database, which goes back to that search function, meaning that if someone else was applying for a mark similar to yours, they would be refused to register. Now, you also have the ability to use the circle R symbol, which everyone will see out in the marketplace attached to brands, as we exemplified earlier, such as Adidas or Coca-Cola, which puts the world brand or the United States and other users on notice that you have a federally registered mark. Now, federal registration also supports the basis to file in a foreign country. If you do business in a foreign country and you want to register your mark in that country, this will help support that application. Also, this gives you the right to bring an infringement suit against someone else who may be trying to copy your mark in federal court and open up some damages for you against that copycat and or that entity that's trying to maybe make money off of your brand. Now, a few miscellaneous items related to trademarks. Registrations with the USPTO don't have a time limit, but you do have to maintain it properly with them, meaning that they have set out a schedule, which every couple of years you have to file maintenance documents, essentially asserting that you're still using that mark and support your continued ownership of that mark. Now, even if you don't qualify, say you're not doing interstate commerce and you don't have the intent to do so, but you want to put the world on notice that you're kind of claiming ownership of this mark, you can put the TM or SM on your mark. I'm sure everyone has seen that in the marketplace. And that's really, that kind of gets back to that common law way of putting others on notice. Hey, that this is my mark, I own it, and I'm claiming the ownership of it. So another item is the fees. And so when you file for an application, you file your application according to certain international classes, meaning the classification that you want to use your mark in. If you had t-shirts, then you would seek a classification related to clothing. Now, for each class, you seek to classify your mark, and you can do more than one, but it's $250 per class. So you'll want to think about that when going through the process to determine whether or not or what your costs will be in filing. And if you need a trademark attorney, then you also want to factor their fees in as well. Next, let's talk about patents. A patent covers inventions. I'm sure many of you have heard of patents. They are issued typically for a limited time frame of around 20 years. Like with trademarks, you will seek to register your patent or get a patent through the United States Patent and Trademark Office, the USPTO. There are certain types of patents. There's utility patent, design patent, and plant patents. A utility patent is granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. Now, a design patent is granted to anyone who invents a new, original, and ornamental design for an article of manufacture. Plant patents are granted to anyone who invents or discovers or asexually reproduces any distinct and new variety of plant. So when applying for a patent or thinking about what business creation or issue you have, you'll want to see what type of patent you might want to file. Now, as for general information, when it comes to patents, for an invention to be patentable, it must be new and not obvious. So meaning it's not common knowledge of everyone in the general marketplace or out there in the world. Now, you can seek a patent if you are the inventor, or you can employ someone who's registered to apply for patents with the USPTO. Now, this can be an attorney. It doesn't have to be, but you'll want to make sure that they have the proper credentials to do that. The patent is a first to file system. The patent office uses the first to file system, which grants a patent to the person who files it first, unless it was known to the public prior to the application, which is something you'll want to take into consideration as well. And lastly, filing a patent can be an expensive process. There are various iterations that you have to go through and application steps. Again, you'll want to probably speak to someone who's familiar with the process, or make sure that you're well versed in what you'll need to do if you intend to try file it for yourself. The last area we're going to talk about when it comes to Intellectual Property Day are trade secrets. Now, trade secrets can be a secret formula, a process, a pattern, a customer list, or potentially any other item that's specific to your business that you do not want the world to know. In other words, trade secrets are something special about your business, which makes your business unique and or more successful than those around you. I mean, we want to think about the famous Coke formula here, or something like Google's algorithm. Both of these things have made both these companies exceptionally successful, and they want to make sure that they maintain that success. So they'll want to keep their trade secrets and the things we've just talked about secret from others, so that they aren't replicated and damage their reputation or success in the market. Now, you can't keep others from developing the same. Google can't keep others from developing their algorithm similar to theirs, assuming it's done properly. They can do things such as require their employees to enter into agreements, assuming they're aware of the algorithm that will prevent them from disclosing it to others. So really, as we move through trade secrets, what is a trade secret other than what we've discussed? Let's kind of put some substance to it. A trade secret is not known or readily accessible by competitors. It has a commercial value or provides a competitive advantage in the marketplace. And the owner of the information, meaning you, protects it from disclosure through reasonable efforts to maintain its secrecy. Meaning just what it says is you have to take some type of effort to keep others from finding out about it. So part of protecting a trade secret is it must stay secret. So it'll lose any protection if someone independently discovers it or reverse engineers it, or if you publicly disclose it. I mean, some of the discussions around tech is open source. Well, if that code is open source and you put it out into the public, it means you don't have dominion over it as a trade secret anymore. Now, there's also the Defense Trade Secrets Act, which provides a civil cause of action for victims of trade secret espionage or theft, where their trade secret has been misappropriated. Now, as with most federal acts, there are certain requirements. It requires that the misappropriated trade secret is related to a product or service used in or intended for use in interstate commerce. Again, interstate commerce gives the federal government authority. Also, the owner must have taken reasonable measures to keep the information secret. And also the information derives independent economic value, which actual or potential, from not being generally known to and not being readily ascertainable through proper means by another person who can obtain economic value from the disclosure or the use of that information. Now, part of that is that you'll have to take actions to reasonably protect it, and such as non-compete agreements or non-disclosure agreements with the employees who have access. The trade secret is restricted to only a few persons. I think with the Coke formula, it's always stated that no more than 1 or 2 employees and or people ever know it at one time. Maybe you've taken the step to create encryptions or passwords to protect that algorithm or development of it. And you've also maybe trained employees on protecting and handling that appropriate trade secret so it's not disclosed. So these are the items that you'll want to take to make sure that you protect that trade secret from disclosure so that you maintain protection and dominion over that trade secret and keep the public from getting their hands on it such that they could replicate your business and cut you out of the market. Now, let's talk about intellectual property budgets. These can vary depending on what you want to do, whether or not you're filing copyrights, patents, trademarks, or you're just keeping a trade secret just that a secret. And some of this is comparable to the steps you'll take. I mean, if your intellectual property is formulas or customer lists or digital code, then it just all depends on the steps that you want to take to protect it. I mean, if it is a formula and you allow 1 or 2 people to have it, and then you also keep it in a password protected safe, well, that's obviously not something that requires too much capital to do. Now, if you have some type of code and you have to make sure that it is protected through encryptions and passwords and digital networks, well, that may increase your value or your cost. I apologize. So, when it comes to budgets and money, you've got to assess what it is you want to protect or and how you'll do that. If it is a brand that you're going to put out in the public, then you may want to consider trademarking it, or about just seeking a federally registered mark. Well, then you need to consider the cost of the application fee and potential attorney's fees. And you may want to think about in the future, if it's likely to be copied, then you may have to pursue some type of action. Some of this is simply a letter from an attorney requesting, or a letter from yourself requesting that the person stop using it. And if they continue to do so and you think you have grounds, well, then you may need to seek litigation, which will cost more as well. And the same for patents is, if it's something that you need to patent, well, then you will need to think about the potential cost of the patent and the basic fees, not to mention maybe hiring someone who's registered to make that filing. So now, one other item that we should probably talk about is, and I've alluded to it a little bit, are ways to protect your intellectual property. We talked about encryptions and passwords for trade secrets, but as I mentioned with the trademarks, in a letter to someone using it, well, that's really a cease and desist letter. Typically, a cease and desist letter requests that the user stop using it, and or you may have to pursue legal action. Now, if you have to pursue legal action, naturally that's a lawsuit. But another item that we haven't really talked about is, maybe you're okay with there are people using it, and maybe that's how you want to monetize it. Well, then you might want to just license their use and make money. And so what you'll need to consider is drafting contracts or agreements with that party regarding their allowed use and the appropriate monetary amounts that you'll seek. So, and maybe a time limitation or some other type of limitations. And, you know, consulting an attorney would probably be a good idea when it comes to drafting these contracts so that they make sure that you're appropriately protected. Now, in conclusion, and again, thanks for listening to me today. But as we conclude and you start to, many of you I know are out there, you know, about to start a business or thinking about a business that you may want to start, or maybe thinking about your next creative endeavor, some things that you want to think about is, what type of intellectual property do I have? Do I have copyright material? Is my brand something I want to trademark? Is my invention a patentable invention? Or is simply what I have a trade secret? Next thing let's talk about is, what are the best ways to protect it? Do I need to register it with a particular entity? That being maybe a state agency or a federal agency. Or do I need to make sure that I have the proper agreements in place, whether it's with employees or contractors? And what type of secrecy do I need to make sure surrounds my intellectual property, such that I'm able to maintain dominion over it? And then lastly, what are the costs going to be, and what type of costs will I incur? Will this be registrations? Will this be attorney's fees? Will this be, you know, internal budgetary items such as training employees, agreements with employees, or maybe as simple as having a safe in your office? So I hope everyone here has learned a little bit about intellectual property. My information is on this last slide here. Please feel free to give me a call or shoot me an email, and I'll be happy to talk through any items or any questions you may have, and see how I can help you in starting your new business. So as we conclude, I just want to wish you good luck in your future endeavors, and thank you for spending these last few minutes with me. Thank you.
Okay. Okay, there I am. All right. So, Josh, that was a great presentation. Before I hand it over to you, I want to apologize for those who are looking at the replay, and for those who had a hard time getting in. We had some technical difficulties while we were going through the Josh presentation. I reached out to some of you who I got a chance, that I actually had their information, and reached out to you all to just make sure that you guys weren't having some technical issues. A lot of you guys were having technical issues, and some of them are still having some, I guess. And some of you, you know how you register and then you forget. So I got to do a better job at reminding everyone. But I want to thank you guys for being here. And Tabitha, thank you for coming in. If you have any questions, please, I know you missed some of the stuff, but we got Josh in here, so you can ask any questions that you want. And you have access to him. So even after this. So Josh, I'm going to hand it over to you.
Well, for those that will maybe seeing this later, feel free to look at that last slide, shoot me an email, give me a call. I'm always happy to, brainstorm with you. I'm not going to charge you for an initial call or anything like that. We love partnering with our clients just to kind of help them get started and just kind of see how we can help each other. So, feel free to shoot me an email, give me a call. I have no problem walking through some items with you, or if you just have a quick question, hey, I'm happy to answer that too. And it's not a big deal, or definitely is not something I'm going to try to be like, turn around and send you an invoice for. So feel free to reach out and like I said, just see or talk with us about any kind of questions you may have, or just brainstorm. So if y'all have any questions, I'm happy to answer them. Otherwise, like I said, just feel free to shoot me an email and I'll get back to you, or give me a call.
Now, I did get some questions. I'm sorry, that's my bird clock. It's been embarrassing, so I'll let it tweet a little bit. Okay. So I did get a couple of questions that had came in while the presentation was going that was text to me. And one was, how difficult is it to protect an actual recipe?
That is an interesting question. I'm not I don't know how to answer that, how difficult, but what I would suggest is that if you are the chef, or you're hiring a chef, and or you're hiring cooks, or other personnel, that you have non-disclosure and non-compete agreements in place, especially with a chef that may be creating recipes on your behalf. If you own the company, well, you're going to want to own those. So
Okay.
you're going to have various agreements in place such that anything that the chef creates while you're paying the chef to do it on your behalf is actually your property, not theirs.
Would that require I know you mentioned contracts at
Mhm.
toward the
Yes.
end, so you would have to basically have a contract saying that, hey, whatever you create is I
Right.
own,
Yeah.
and then also include that NDA.
I would do both of those.
Okay.
Absolutely.
All right.
Now, and then as far as, protecting it, that depends on where it's stored, but I wouldn't, like we talked about in the presentation, don't just give it out to everybody, and make sure that it's under lock and key, depending on how important it is.
Okay. All right. That stems another question that I have heard, and that is how I've gotten this from several clients, and just in discussion or listening to them. And some of the questions that come up when it comes to NDAs is how concrete are they? How concrete are NDAs, and are there different types of NDAs? Those are the two questions that come up the most when I'm talking to clients.
That's a great question. Let's start with, so I'm not sure about what different types there might be, and I'm not sure what we're getting at there. But as far as enforceable, your NDAs are just contracts. They're enforceable in the courts. Now, recently, so this kind of goes into non-competes, because they're kind of the similar type deal, where a non-disclosure is telling you, okay, you can't go disclose our confidential information with us, just like you can't go compete with us if you work for us, because we've trained you and spent money on you. And I will say that in Mississippi, some states are different. So it can depend on what state you're in, but it really is just reviewing the law real quick to see how enforceable they are within your state. Sometimes I can speak to non-competes recently in Mississippi, where typically they have to be geographically limited, reasonably time limited, and things like that. I don't mean to get off topic, but what I was getting at is, usually if there are reasonable parameters within your non-disclosure agreements and your non-competes agreements, then they're generally enforceable. But again, that goes back to the particular state that you're seeking to enforce that in.
Okay. All right.
But I
So
would definitely, if you have important trade secrets and other information, just as a very initial precaution, regardless of how enforceable it might be, I would still put it in the contract.
okay. And you mentioned that in the state of Mississippi, one of the things is recently that they want you to be more specific as far as geographical and time.
Well, no, I was actually going the opposite direction with that.
Oh,
No, which is okay. It brings up a good point. So it had to be reasonable. So usually you can't prevent the person from making a living within a reasonable time, within a reasonable geographic area. So in Mississippi, there were cases that within 3 counties was okay. That was reasonably limited. 3 counties, they had to go outside the 3 counties to compete. That was okay. Recently, they just had a case come down where it did not have a geographical limit, and there were some other factors to that case, but they upheld the non-compete.
oh, okay.
But there are some fact-specific nature to that case, but nonetheless, they upheld it. But as an attorney, when I draft non-competes, I also am a business person myself and a human being. And so depending on what the type of business my clients in, or what their geographical area is that they compete in, I speak with them about, okay, you try to still want to build good relations with the people. Let's not try to prevent them from making a living themselves, but we want to protect your business. So where's our reasonableness there?
Okay. All right. That's good info. Really good info. If anyone else has questions, let me know. I'm just reading the questions that I received. Another one that I received was, how effective is a cease and desist letter?
That depends. A lot of it depends on your standing with your intellectual property. If you have a very strong case, like if you have a federally registered trademark and they were using the exact same mark in an area that you compete in, and you had the mark registered or used it in their area prior to their use of that mark, you got a really strong cease and desist letter.
Okay.
Because you're laying that out and you're basically telling them you've got no case, and if you don't stop, I'm going to file a federal lawsuit against you. Now, if they're just like the reason lawyers have jobs is because there can be some gray area out there, and if your rights, your intellectual property, say you don't have a federally registered trademark, you only have what's called a common law right, meaning it's not federally registered with the USPTO. Well, then there may be some rub there. There also may be some rub if they were using the mark in that specific area before you had it federally registered. So then your cease and desist letter, if they got an attorney, they may point that out, and you go back and forth. And again, that might get you to a point where you just kind of either you agree to license it to them, or you understand that, okay, they've got a good case. If you decide to use it outside that geographic area, well, then I'm gonna come back and send you another cease and desist letter. So it really depends on how strong your case is with your intellectual property. Now, that doesn't mean you shouldn't necessarily send one, but it just means that they may ignore you, and then it's up to you to depend on how strong you feel your case is and how hard you want to go after them, and what your budget looks like. Because then you're going to be hiring an attorney to probably draft your cease and desist letter. And then if you feel like you got a good case and they're ignoring you and they don't want to respond or cease and desist, well, then you may want to file a lawsuit. And then again, that's going to cost money. So, but again, to get to back to your point, to circle back, the cease and desist letter all depends on how strong your rights are in the intellectual property and what the infringer is doing.
Okay. All right. And you mentioned budget. And I know that plays a big part. Now, a lot of times we're trying to budget things make a really good budget for our business. And so, is there, and I know this is a very broad question, but is there a dollar range that every small business owner should at least have allocated to legal fees when it comes attorney fees or actions when it comes to their business? Like those very specific things that, that the bare minimum of what they will definitely need if they're a small business owner. And when I say small business owner, let's narrow it down to a solo entrepreneur.
Okay. And are we talking getting the business started, or are we talking intellectual property?
Just getting the business started.
Okay.
Yeah.
So from a very initial perspective, you got very basic items. So you've got to register your business. Well, let's put it this way. So if you're creating a business entity, you're going to want to have limited liability in that business entity, so that if something goes wrong with your business with a third party, they can't come get your house and your car and some things of that nature. So what you're going to do is create. So one of the most common forms of businesses these days are LLCs, the limited liability company. And So what you're going to want to do is you file the registration with the Secretary of State of the particular state in which you're registering. That's going to have a basic fee depending on what your state is.
Okay.
And then, if you're solo, this is important regardless to me, as and many banks require it, is going to be your operating agreement. Your operating agreement for your LLC basically runs your business. It governs your business is a better way to put it. So it lays out, if your partners, it's easier to explain, because what it does is the operating agreement will lay out between the partners when a partner can sell out of the business and who manages the business, or what and how, what voting rights does each member have in that business. So you're going to want an operating agreement. So you're going to want to hire an attorney to do that. Now, that's not to say you can't do all these things yourself. It just depends on what level of comfort you have with these kind of items. Attorneys, we do it all the time. That's our expertise. That's what we do. So it just depends on how comfortable you are with it and what level or how much money you want to spend. An operating agreement, setting up your LLC with the state, with fees, is probably going to cost you somewhere between $1,000 and $2,000.
And if you throw trademarking, like if you have a logo and you know what your logo is or your slogan, and you want to throw that in, what do you think that range would be?
So for trademarks, I can tell you that, like we talked about in the slideshow, that to file your trademark, you have to file it in at least one international class. You can file it in more classes, but the USPTO charges $250 per class. And the fees just changed, but I believe that's still the fees. $250 per class. Let's see here. I was trying to think if there's any additional fees associated. That might be the only application fee, but you still have to run your due diligence. And so you're going to want to, you can, again, that's something you can do yourself, but even the USPTO generally recommends hiring a trademark attorney to do that. Just begin, because we're comfortable with it. We do it all the time. We know what we're looking for. So generally, to file a trademark with one class is going to cost you somewhere around $1,500. That's your due diligence. And I'll tell you, what we do is we usually do a flat fee that includes the due diligence cost, the filing fee, and our fees. And what that will do is that gets you the application filed. Now, in trademark specifically, is after you file your application, the USPTO can come and challenge your application. Essentially, what they're saying is, hey, you've got some issues here. Like we talked about, it could be descriptive or generic, or they may say this is too similar to another mark, so confusingly similar. We need you to tell us why you don't think it is. And those are called office actions. Generally, what we do is I will charge the flat fee to do the application. And then what I usually explain to the client is that if there are any office actions, we will assess the office action, contact the client. And if it's something very simple, if it's something as just confirming that we need to disclaim certain things in the trademark to get it, not a big deal. We'll just do that, not a problem. But oftentimes an office action can require a response that is kind of like a legal brief. And at that point, generally we start working off an hourly fee, which is something we discuss with our client, and we'll walk it through them. This is what it's going to take. This is what it's looking like. So the fees could go a little bit higher, but on the front end, you're looking at about $1,500.
Right. Now, one of the things when you're registering when you've registered your trademark, there are a lot of times that you get, what do you call it? It's mail that tells you, is this mail that tells you, hey, you need to pay X number of dollars to, for your trademark or your, so how do you tell what is specifically, an official letter about your, mark or your patent or whatever, and something that is just fishing to get your money?
So generally what I have noticed with my clients that I've filed trademark applications for is they almost immediately get some type of letter in the mail. And what I tell them is that because everything that you file with USPTO and the federal government is publicly available information. And I tell them, I say, I tell them, if you receive anything in the mail, let me know and let me look at it. Now, if you're filing yourself, generally the way that when the U.S. Patent and Trademark Office communicates with the trademark owner and or the attorney, they kind of, for us in the legal world, it's like a docket. So, but what it is you can go to the USPTO website and pull your trademark and pull that file, and it'll show you the communication and or the actions that the USPTO has taken in regards to your trademark. And so generally, if you got something in the mail and you think it's from the USPTO, you could go to your trademark file and take a look at it and say, well, that's weird. They don't show where they issued me an office action or a maintenance action. That doesn't look right. So, and at that point, you would kind of have an idea, all right, something's not right here. But again, that a lot of it too boils down to taking a look at what you receive and having to take a hard look and say, does this seem like a third party? And generally some of those things will say, like, I just had a client, or we registered a new company with the Secretary of State, and they received a letter from a third party. And at the bottom, in very small print, it said, this is not from the Secretary of State's office. This is a third party.
But it looked official. Okay.
And they wanted them to pay X amount of money to get a separate certificate of registration. Well, when they called me, I said, no, if we need that, which we don't need right now, we can go get it from the Secretary of State for a much cheaper price.
Okay. All right. That's anyone else have any questions for we got a question in the chat. Should I register my business first, then patent whatever my logo I create to use?
Well, so the patent is a little bit different for me because I'm not a patent attorney. I know a little bit about it, but to be a patent attorney, you have to also have certain credentials and pass the patent bar. So I don't want to speak to that aspect of it. But if you have a patentable thing, shoot me an email. I'll put you in touch with somebody that can absolutely answer your questions and help you pursue that path. From a trademark perspective, there are lots of individuals that are on their trademarks. And if you don't have a business, what I would say is if you have a business where you're doing business in the marketplace, then you probably need to create an entity for that business. So I would think on that aspect, yes, just go create your entity, then file your trademark. I mean, creating an entity you can do pretty quickly. And get everything rolling, and then you can register your trademark and the entity will own that trademark, or you can own it personally. Either one can own it. But if you eventually want to sell your business that includes that trademark, well then, and the trademark is part of the value that you're selling, well then you're going to want it to be a part of your entity, because what's going to happen is you're going to have to do a few extra legal hurdles to get the trademark assigned to your entity. So then you can sell it all to the purchasing party. Okay. If they're buying the entity. Now they could just buy the trademark from you. And if it's not a part of the entity, well, that's kind of a different question. But what I would say to start off is if you're running a business out in the marketplace, go get your entity. And if you have a brand, just go put it in the entity's name as the owner, especially if you're a solo entrepreneur.
Okay. All right. Do we have any other questions? Okay. Well, listen, I have Josh information for you all. Josh, do you have anything additional? I think I went through all the questions that I got. Protect the logo, effects of a cease and desist, and the recipe. Those were the only 3 questions that I got in. Let me check to make sure that I haven't gotten any more. That is it. So do you have any final words?
I don't have anything final, but good luck. Go start a business, go get in the marketplace, work for yourself, and enjoy it. But again, if you have any questions, feel free to shoot me a call or shoot me an email and I'll get back to you.
And again, I want to thank you all for being here. I mean, I'm sorry for the technical difficulties up front. We will definitely have this on our YouTube page so you guys can go back and look at the presentation from the beginning. I have personally dealt with Josh, and I'm gonna tell you, he is amazing. So if you're thinking about, talking to an attorney or hire an attorney for me for anything, I'm telling you, him and David Ash are amazing. They really are. And they're always available to answer your questions. But just remember that when you're dealing with business, a lot of times we think that everything, this sounds weird, everything should be free. It's not. Even information, I hear this all the time. And this is one example I want to give you guys before I leave, before we close out tonight. I remember hearing someone that says, why do people always keep their information to themselves, when they're starting a business or when they've made it? I'm your friend, I know you, why don't you share this with me? Or information is free. If information was free, you would have it. It takes time to learn that specific craft. It takes a lot of time and energy, and you have to look at what that person has went through to get to where they are. And if they don't want to share that information, it might feel bad, but that is their choice. We can always go get it hire someone to give that a consultant, an attorney or something like that to help us with that information. And I'm gonna give you an example. The things that I do now as the founder of Combat Boots to Red Bottoms, when I sit down with clients, a lot of times I give a lot of information out for free. But when I was in the military, I was a counselor. And soldiers came to me and they talked to me about all kinds of stuff. I did contracts for them, made phone calls, did research, and taught them how to get from point A to point B. They never paid me one dime, but somebody paid me. The federal government paid me because I was a soldier. And they paid me, they sent me to school to learn that craft. And that was my specific job. So I got paid to do that. So what I don't want you guys to feel like it's a slap in the face if someone, is requiring you to pay for that information or is not ready to share that information, because you got to look at everything they went through. I want you to look at the public school system. People send their kids to school every day in the public school system. They don't pay anything to send their kids to school. That teacher teaches that child every day in class. But the parent doesn't necessarily pay the teacher directly. The child doesn't pay the teacher directly, but someone pays that teacher for his or her knowledge and time. So I want us to get to a position to where we are happy and enthusiastic about hiring professionals like attorneys and consultants and accountants, because that is a foundation that you need for your business. Bookkeepers, things of that nature. A lot of times we are doing it by ourselves and we make mistakes, and then we have to pay for it in the long run, and it costs us more money. And this is why people like Josh and David and accountants and consultants are there to help us with our business on a professional level. So with that, I'm gonna get off my soapbox. Because I'm gonna tell you, Josh, David, my accountant, they're always getting on me about giving away free stuff. Stop giving away free stuff. And I appreciate that that mentorship from them. So if you definitely want someone who's going to keep it real with you, who's going to be honest with you and lead you in the right direction, please give Josh a call. Give him a call when it comes to things like this. So if I don't have any other questions, I enjoyed being with you all today. You can send me a message anytime you want to. If you can't find Josh info, which you should be able to, you can always go to www.combatbootstoredbottoms.com. or you can shoot me a message also. And you guys have a really good night. Thank you for joining us. And thank you, Josh, again for being here.
Enjoyed it. Thank you.